So I filed bankruptcy. Well, I have to go to court. People who come and see me are often very nervous about the idea of going to court and thinking that someone is going to interrogate them on why they had to file bankruptcy. That is not exactly how bankruptcy works. In fact, that is not how bankruptcy works at all. About 30 days after you file your bankruptcy, you will have to attend a hearing called the Meeting of Creditors. Your attorney should tell you when and where this meeting will take place. At that meeting, the trustee is there to ask you some questions regarding your bankruptcy petition, but there is no judge present at this hearing. It is just a room with other debtors, their attorneys, and the trustee. Creditors can show up and ask you questions about your financial situation, but it's pretty rare for creditors to actually appear. The ones that usually show up are usually non-bank creditors, like personal loans, or ex-spouses looking to cause problems. The meeting of creditors is usually a very straightforward meeting to make sure that everything is correct in your filing, and then you're done. When your case is called, the trustee will swear you in and ask you to state your name and address for the record. The trustee will also ask your attorney to state her name for the record. Then the trustee will ask a series of questions that he asks all of the debtors, including asking if everything submitted was truthful and accurate, if there are any errors and omissions, and if you signed all the documents before they were filed.
Sorry, pick that up from the
Okay. Then the trustee will ask a series of questions that he asks of all debtors, including asking if everything submitted was truthful and accurate, if there are any errors or omissions that you want to let the court know about, and if you signed all the documents before they were filed. Once he finishes the standard questions, he may ask any questions he has about your assets to make sure they are valued correctly and the proper exemptions were used. The questions may include how you valued the item, where the item is located, and any other details about the asset. At the end of the questioning, the trustee will ask if there are any creditors present, and there usually aren't, and then he will conclude your meeting and you're all done. There is the possibility of other hearings that you may have to attend, but they are fairly rare. For example, if a creditor objects to your discharge because of fraud or for some other reason, there may be a hearing set in front of a judge to hear evidence and rule on the creditor's objection. Also, Chapter 13 cases will often have a confirmation hearing set on the calendar, so that the judge can approve your plan and talk with the trustee and creditors about any issues he has. For the most part, this hearing does not actually take place if there are no issues on the record, and the plan is then approved automatically when all issues are resolved. Your attorney will advise you of any hearings that are set to take place in your case, and also advise you on whether you need to be at the hearing or not, or just your attorney has to be there. I'm glad you joined us today. Please contact me if you have any further questions.